Welcome once again to Lehto's Law. Here's Steve Lehto.
I've got a U.S. Supreme Court case we got to talk about, and it ties into the video I did not so long ago. You'll recall the story about the guy whose house the police showed up at. They were at the wrong house. They knocked on his door, and when he came down, it wound up being a fatal shooting where he died. And if you look at the case, you go, that's crazy. But the lawsuit that was filed on behalf of his widow was thrown out on qualified immunity grounds because the court said, well, when you glance at just the narrow time frame within which this happened, the shooting was justified. And I had said that, well, in my mind, if you are going to look at the circumstances, you should probably look at a larger context as what actually happened. But the court there said, well, we're bound by the precedent in our circuit, and our circuit's often held that we look at this really, really narrow moment of time. And so another case involving a shooting that took place in a very narrow window of time was heard by the Supreme Court, Barnes versus Felix. Barnes versus Felix. And this case talks about excessive force and, of course, whether or not qualified immunity will apply and so on. And interestingly, I should point out that the court never actually mentions qualified immunity, but I think they do that because they just assume everyone knows that's what we're talking about. But in this case, which, by the way, the ruling was unanimous, a police officer's use of deadly force violates the Fourth Amendment when it is not objectively reasonable. That inquiry into reasonableness, we have held, requires assessing the totality of the circumstances. And the court is saying here, we're not making new law here. We're just reminding you what the law actually says, because they've been ruling this way for a while. But the lower courts have been saying, well, the totality of the circumstances is limited to that narrow window of time, and the Supreme Court never said that. So the question here in Barnes versus Felix is whether that framework permits courts in evaluating a police shooting to apply the so-called moment of threat rule used in the courts below. So the courts below had come up with this moment of threat. We should not look at the totality of circumstances. We'll look at the moment of threat, the narrow window. So here's what happened. Back in 2016, a man named Felix was a law enforcement officer patrolling a highway outside Houston. And he got a call on the old hoot and holler about an automobile on the road with outstanding toll violations. He spotted the car, which was a Toyota Corolla, and flipped on his overheads to initiate a traffic stop. The driver, Barnes, pulled over. So the police officer parks his car behind the other car and then walks up to the Corolla's driver's side door and asks the man for his license and proof of insurance. He said he didn't have those with him, but he was rummaging through the car, and the police officer said, stop digging around. The officer then said he smelled marijuana and asked if there's anything in the car he should know about. Then the man responded that he might have some ID in the trunk. So the police officer told him to open the trunk from his seat, which the man did. He also turned off the ignition. However, this all happened very quickly. There's a dash cam recording of the entire incident, and what I just told you all happened within 2 minutes. Then things began moving faster. With his right hand resting on his holster, the officer told Barnes to get out of the car. Barnes opened the door, but did not exit. Instead, he turned the car back on, at which point the officer unholstered his gun, and as the car began to move forward, the officer jumped onto its door sill. He twice shouted, "Don't effing move." And with no visibility into the car, because his head was above the roof, he fired 2 quick shots inside. So the man was hit, but managed to stop the car. The officer radioed for backup, and by the time it arrived, Barnes was dead. All told, 5 seconds elapsed between when the car started moving and when it stopped. And within that period, 2 seconds passed between the moment that the officer stepped on the door sill and the moment he fired his first shot. And the courts, as you're going to see, focus on that 2-second window. So Barnes' mother sued the officer on her son's behalf, 42 U.S.C. 1983, alleging that Felix, the officer, had violated Barnes' Fourth Amendment rights by using excessive force against him. The district court granted summary judgment to the officer, in essence throwing out the claim, explaining that to prevail in her case, Barnes's mother needed to show that Felix's use of force was objectively unreasonable. And in the usual excessive force case, the court noted the inquiry into reasonableness would involve considering a variety of circumstances. But when an officer uses deadly force, the court continued, the Fifth Circuit has developed a much narrower approach. So the Fifth Circuit has developed its own approach. A court then asks only about the situation existing, and this is a quote, at the moment of the threat. At the moment of the threat. The district court identified that moment as 2 seconds before Felix fired his first shot while standing on the doorsill of the moving vehicle. At that moment, the court found an officer could reasonably think himself at risk of serious harm. And under their rule, that fact alone concluded the analysis. The court explained that it could not consider what had transpired up until those last 2 seconds, including Felix's decision to jump onto the sill in the first place. Remember, this is all about tolls, remember? Unpaid tolls. So, although a more robust examination might have aided in assessing the reasonableness of the shooting, the court was duty-bound by circuit precedent to limit its focus to the exact moment Felix was hanging onto Barnes's moving car. So notice the Supreme Court saying the Fifth Circuit says they're following their own precedent, but they're not following ours. And that's what they're saying here. The Court of Appeals affirmed, explaining that it was duty-bound by this circuit's moment of threat doctrine. Under the rule, the panel agreed the inquiry is confined to whether the officer was in danger at the moment of the threat that resulted in his use of deadly force. Any prior events leading to the shooting, including actions the officer took, were simply not relevant. And then in a concurring opinion, this is interesting, a judge on that appeals court actually said that he had concern with the moment of threat doctrine. He thought the rule was inconsistent with the Supreme Court's directive to assess the reasonableness of the use of force, including deadly force, by looking at the totality of circumstances. So who said the totality of circumstances is 2 seconds? Where'd that come from? That's what the Supreme Court's asking. Under the totality approach, the judge wrote, a court could consider not just the precise millisecond when an officer deploys force, but everything that had transpired up until that time. With that wider focus, the judge would have found that Felix's shooting was unreasonable. So Supreme Court granted cert to address this, and we hold that courts may not apply the moment of threat rule as described because that rule constricts the proper inquiry, which is the totality of the circumstances. So again, the Supreme Court said, we've already ruled on this. Where'd you guys get this moment of threat rule from? You made it up? Is that your job? So a claim that a law enforcement officer used excessive force during a stop is analyzed under the Fourth Amendment. The touchstone of the Fourth is reasonableness as measured in objective terms. So the question in a case like this, as this court has often held, is whether the force deployed was justified from the perspective of a reasonable officer on the scene, taking due account of both the individual interests and the governmental interests at stake. Now, keep in mind that reasonableness is always open to a lot of interpretation also. So that's not a real good bright line rule, but they're saying that it's the reasonableness and the totality of the circumstances. That inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. And there is no easy to apply legal test or on-off switch in this context. Rather, the Fourth requires, as we once put it, that a court slosh its way through a fact-bound morass, or said more prosaically, deciding whether a use of force was objectively reasonable demands careful attention to the facts and circumstances relating to the incident as then known to the officer. For example, the severity of the crime prompting the stop. So the question is, in this case, unpaid tolls, or in the other case, it was a domestic violence call at a different address, okay? So too can actions the officer took during the stop, such as giving warnings or otherwise trying to control the encounter. And the stopped person's conduct is always relevant because it indicates the nature and level of the threat he poses either to the officer or to others. So in this case, a man fires his car up and starts driving away. Now, the question is, how dangerous is that the officer if the officer didn't jump on the door sill? So most notable here, the totality of the circumstances inquiry into a use of force has no time limit. The 2 seconds or 5 seconds shouldn't have done that. The situation at the precise time of the shooting will often be what matters most. It is, after all, the officer's choice in that moment that is under review. But earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Or as the federal government puts the point, those later in-the-moment facts cannot be hermetically sealed off from the context in which they arose. And that's the government writing. Taking account of that context may benefit either party in an excessive force case. Prior events may show, for example, why a reasonable officer would have perceived otherwise ambiguous conduct as threatening, or instead they may show why such an officer would have perceived the same conduct as innocuous. The history of this interaction, as well as other past circumstances known to the officer, may inform the reasonableness of the use of force. So the moment of threat rule applied in the courts below prevents that sort of attention to context and thus conflicts with this court's instruction to analyze the totality of the circumstances. So the court is again reiterating that they've already ruled on this. This is not new law. They're simply reminding the lower courts to follow the ruling of the Supreme Court and stop making up your own precedent. Recall that the district court and the Fifth Circuit limited their review to the 2 seconds before the shooting after Felix had stepped onto the door sill of the car. Those courts believed that under Fifth Circuit precedent, they could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier conduct of an interactions between the suspect and the officer. And because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set within a longer time frame. So the court goes on to point out that even Felix, the police officer, in this case, notes that you could look at a longer time frame. So rather than just saying, hey, look, we agree with the Fifth Circuit, Felix's attorneys, and he apparently said, well, no, you can look at it, but points out that prior events are not off limits in the reasonableness inquiry, for they may inform the perspective of the reasonable officer, and that's a quote from the brief. But now they diverge. According to Felix, the courts below acted consistently with that all times considered principle. The Fifth Circuit's moment of threat doctrine, Felix argues, in fact allows courts to assess many pre-shooting facts and circumstances, and courts applying it often do so. All that the doctrine bars is a single kind of inquiry into whether an officer's earlier error itself created the need for deadly force. So he says, look, I don't have a problem with you looking at time before the shooting. It's a question of whether I made a mistake that led to this or caused this. And on that issue, Felix submits the Fifth Circuit is right. An officer doesn't lose his right to defend himself just because he previously made a mistake. But whatever might be said of Fifth Circuit law generally, the decisions below apply to rule about timing. As shown above, both lower courts took pains to explain that in evaluating the reasonableness of the shooting, they could look only at a 2-second snippet of the encounter. Because that was the reasoning in the case before us, that is the reasoning we address. It could make no difference to our decision. Here, the Fifth Circuit in other cases eschewed a strict time limit, as Felix claims. And anyway, we are not sure Felix correctly describes the overall state of Fifth Circuit law. And they actually do talk a little bit about the law in the Fifth Circuit. But the court ends by saying, we do not address here the different question that Felix raises about use of force cases, whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis. So in other words, the attorneys for the officer are apparently arguing, if you look at earlier things, all you can look at is whether or not the officer made a mistake that led to the shooting. And the court's saying, no, they can look at everything that led to the shooting, mistakes or otherwise. So, as in another of our recent Fourth Amendment cases, That issue is not probably before us. So believe it or not, the lower courts never addressed the making of a mistake by the police officer and leading to the shooting. And so the court says here, we're not going to address that. We're not going to address that. The courts below never confronted the issue, precisely because their inquiry was so time-bound. They only looked at the time. They never even addressed mistakes made by the officers. So in looking at only the 2 seconds before the shot, they excluded from view any actions of the officer that allegedly created the danger necessitating deadly force. And by the way, that's something that is a legal concept. I could probably do several videos on it. But there's a concept in the law that if I create a jeopardy that you're put into, that I might have a duty to help you more so than if I don't. So in other words, if I'm walking by you and you're standing by the edge of a pool and I push you in and you are flailing about because you can't swim, I have more of a duty to rescue you than if I walked by and simply saw you fall in the pool. Because in one of those, I created the peril. And the other one, I simply witnessed it. Now, in some states, they've got, Good Samaritan laws and so on. I'm simply talking about the concept of legal responsibility at common law. And so if a police officer makes a mistake that leads to some kind of problem, that's obviously a little different than if there is no mistake involved. However, the court's saying we're not going to address that because it wasn't raised in the lower courts. So, to use the obvious example, the courts below did not address the relevance of Felix stepping onto the door sill of the car. And because they never considered that issue, it was not the basis of the petition for certiorari. The question presented to us was one of timing alone, whether to look only at the encounter's final 2 seconds or also to consider earlier events serving to put those seconds into context. With that matter resolved, we return everything else to the courts below. It is for them to consider the reasonableness of the shooting using the lengthier time frame we have prescribed. The totality of the circumstances. That's the key. It's not the moment of threat. It's the totality of circumstances. But what I have to point out here is that I've had people tell me, they say, Steve, you did the video about the shooting on the porch of the wrong house. And there's this case called Barnes versus Felix that addresses a very similar issue and appears to say that the reasoning used in the New Mexico case was wrong. And I agree with you that, in fact, it appears they used the wrong standard. But what this means is that that case, assuming that it gets sent back because of this ruling or brought up and appealed, blah, blah, blah. If it gets sent back down, it'll be re-examined on the issue of how much do we look at to determine the reasonableness of the police officer's, plural, action in that case? Because there's more than one police officer in the case in New Mexico. Here we only had one. And there's an interesting question there. Because I personally think, and a lot of people I think agree with me, that entire situation in the other case would not have happened if they hadn't gone to the wrong house. They went to the wrong house, knocked on the wrong door. If they hadn't done that, what followed wouldn't have happened. So in my mind, there's a problem there. But unfortunately, a court could still look at that case and say, true, they knocked on the wrong door. But people knock on the wrong doors all the time. And they could say, the man answered the door with a gun in his hand and very quickly pointed it towards an officer. And they very well could say that the knocking on the wrong door doesn't play into that. Because of the fact that just because you knock on someone's door doesn't mean you expect them to come out armed. Now, I'm not saying that's how I think. I've already made it clear in that video and this video that I think that the police should be held responsible when they're the ones who push over the first domino. And the first domino is knocking on the wrong door knowingly. Because, as that case pointed out, one officer said, in essence, we are at the wrong house. The real house is over there. And then the one officer said, are you telling me I'm wrong? Don't tell me I'm wrong. But he said it sarcastically. But it was put out there. We're at the wrong place. You're at the wrong... Stop knocking on the door of somebody else's house at night when they didn't do anything, okay? And so the real question is, when it's re-examined, Will a court look at this and go, we're going to go all the way back to them being at the wrong house, knocking on the wrong door, and saying that somehow means that that's what precipitated everything? And I can see a court saying, no, there's still issues here for a reasonable officer who knocked on the wrong door to react the way he did. However, that wrong door thing really sticks in my craw. So, this is the case of Barnes versus Felix, and I have to salute the Supreme Court, and I have to, because the entire opinion is 9 pages long, and that's including all of the front matter, which actually takes up a couple pages. So it's actually only 7 pages long. It's a very short opinion, and it's short because the point they're making is so simple. They're saying, look, we did a case years ago saying that you guys in the lower courts, to determine reasonableness of officers in these situations, should look at the totality of the circumstances. Now, totality's root word is total, not partial, not limited, not narrow, totality. The totality of the circumstances. Look at the circumstances. And for some weird reason, some courts took it upon themselves to say, well, the totality of the circumstances is the moment of threat. And the moment of threat here was 2 seconds. How do you get the totality of circumstances in 2 seconds? You don't. You can't. So the Supreme Court rightly, unanimously, overturned this and sent it back down. So as with everything else, having it sent back down, anything can happen still. And the court could still look at it and go, gee, expanding the totality of circumstances out, we still rule the same way. They very well could. So we'll wait and see what happens. But here we have the Supreme Court actually chastising the lower courts for, in essence, inventing their own rules that contradict the Supreme Court ruling that they thought was pretty clear, totality of the circumstances. So thank you to everybody who sent that. Like I said, I'm just reading from the opinion. It's Barnes versus Felix, and the case just came down from the Supreme Court of the United States. Questions or comments, put them below this. Talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I wish life had an undo function.